then Shawn Rader, if you want to jump in, the floor is yours.
Thank you, Jamie. My name is Shawn Rader. I'm with the Lowndes firm. My partner, Jamie Walson, and I welcome you to this webinar. Today, Jamie is going to start by taking us through contemporary lease provisions around which a lot of issues have arisen lately. And I think we'll find that very edifying. When he has completed his presentation, I will then take a few minutes to look at lease provisions that are important for eviction actions, and then walk through the eviction process with you so that everyone is clear on what is required to get your premises back when the tenant isn't paying. So, Jamie, I think that's enough of an introduction. I'll let you take over at this point.
Thanks, Shawn, and welcome to everybody who's watching us, or anybody who's going to be watching us on the recording later. Very much appreciate your giving us the time, and so we'll try to make good use of it. My name is Jamie Walson. I've been with the Lowndes firm for about 18 years now. I have the pleasure and honestly kind of rare this day distinction of doing both commercial litigation and negotiating commercial leases. And so it I think gives me a slightly unique perspective on some of the negotiating points between parties. I'm lucky that given our firm's very deep bench in real estate, I'm part of, and Shawn is as well, of the commercial leasing practice group. And so we've got individuals who are really experts across all types of industries in leases, and we meet routinely about once a month. And one of the questions that always comes up is what are the hot button issues? And the issue that I'm going to lead with is going to be the one that keeps coming up at every single meeting, and it's how are parties addressing supply chain, labor force shortages, those types of issues. After I talk about that, I'm going to talk about some recent trends in renewal provisions, recent trends in prevailing party attorney fee provisions, acceleration of rental, waiver of statutory notice, and then landlord's liens. And so we'll start by jumping into supply chains. But before I do that, let me point out that if any of the participants at this point or throughout this presentation have questions, we have the question and answer feature, not the chat feature, in Zoom open. So feel free to put a question in there, and we will try to get to them, time allowing. So with that said, let's talk about the issue that is at the top of a lot of people's minds. We had a number of our lawyers, actually 4 of our lawyers, went to the ICSC law conference last week, and a lot of the breakout sessions were focused on supply chain issues. And we've all know or have experienced, frankly, the horror stories, right? You hear about the amount of time it takes to get electrical panels or labor shortages. In the same week, both myself and one of my law partners dealt with an identical issue in separate commercial buildings, where it was a 2-story building and the elevator was out. The elevator contractor said, look, we need a part related to the panel. It is going to take us 6 months to get this part. And so until then, you are without an elevator in your building. Totally out of everyone's control, but certainly creates fallout when you say to tenants, we no longer have a functioning elevator for 6 months in our building. I'm hearing from clients issues of permitting delays and the amount of time that the city of Orlando and other jurisdictions throughout Florida are taking in issuing permits and finalizing inspections. And so based on all of this, a lot of the old negotiating positions, hard deadlines, rights to terminate, are no longer valid, and the parties are no longer focused on that. So what are we seeing? First, I think we're seeing increased diligence at the outset of any lease that requires either development or tenant improvements. So whereas the prior standard used to be, look, we're going to sign a lease and then we're going to get together. We'll figure out exactly what the scope of your work is. There's an improvement allowance, and there's not that much that could go wrong. So we'll get you by X date as long as the plans are made by Y. That's no longer the case. And a lot of times what I'm seeing is parties really want to know before ink is on paper, what is the scope of work? And are there any unusual materials that are going to be requested as part of that? Secondly, landlords and developers increasingly are not committing to hard delivery deadlines. Or if they are, these deadlines are being cast incredibly far out. Termination dates in particular, as I'm sure most who are watching this are aware, the usual commencement date negotiation will hone around, first there is an outside delivery date. And if that outside delivery date is not triggered, then there is some sort of day for day rent abatement added for failure to deliver. And then there's an even further date that says, look, if you don't get it to us by 6 months or 8 months, whatever that is agreed upon, then tenant has a right to terminate. Landlords and developers are increasingly saying, no, where there's no way we are agreeing to any termination right associated with development or improvement. Or if they are setting that, they're casting it so far out that it's almost meaningless because it's really far out in the future. I'm seeing parties, particularly landlords, that are trying to shift this burden to tenants through definitions of what is an event of a tenant delay, by putting in language that says a tenant delay relates to anything that is requires a long lead item, and then defining what a long lead is. But increasingly, and I think this is where the market is going to go, we're seeing compromise positions where the parties are agreeing to a definitive development schedule, and really kind of similar to common area maintenance expenses where you have controllable versus non-controllable. They are splitting out design and development or build out items that are within the party's control versus those that aren't. So you would have hard deadlines to get plans submitted for permitting. But then once they're in for permitting, all bets are off. That's not on us. The clock will start ticking the minute we hear back from the municipality. If labor shortages jump in or unavailability of materials, that's another reason to extend. So the provisions are getting more and more complicated to address that. Now, a lot of parties are dealing with these supply chain issues through the force majeure provision. Force majeure literally means superior force. It is a creature of contract exclusively in the state of Florida. There is no common law notion of force majeure. It has to be negotiated and evident in the contract. And so parties are adding supply chains, labor shortages to their force majeure language, and usually coupling that with, look, if there's an event of force majeure, the party stating that there is one has to send notice and has to take action to counter the delay. Now, one of the key things when we think about force majeure is to recognize that economic hardship is never an event of force majeure. Economic hardship can be solved just by writing a bigger check. And so the courts will not relieve a party when that is the solution. It has to be something that's truly outside of the control of the parties. So what are the risks of just staying silent? Let's say we don't negotiate anything on these issues. I've heard some tenants say that they would rather rely on common law doctrines of impossibility or frustration of purpose. And these are doctrines that really go to the fundamental purpose of the contract and allow a remedy if they void the contract, if that purpose is so frustrated that it's rendered impossible. And the problem when we deal with labor shortages or supply chain issues is that in order for impossibility or frustration of purpose to apply, those doctrines are limited where the risk is not foreseeable. And if you've opened a newspaper in the last year, if you've attended this webinar, you know that these risks are foreseeable. And so these common law doctrines really aren't going to apply. So where should it go? In my opinion, face it head on. It's a business term that has to be negotiated early with as much specificity as possible, as much diligence as possible on the front end so you know the scope of the work, and then allocate the controllable risks versus the non-controllable so that the parties aren't liable for things that are outside of their control. So reaching into our grab bag of topics, the second topic is an interesting one to me for the last few years, based on a case that came out in 2018, and it deals with renewal provisions. So, as we're all aware, it's not unusual for a landlord and tenant to negotiate a 5-year option at the end of the original lease, and the big question is, well, how do we determine the rate, the rental rate? And oftentimes, you will see provisions that say it's a 5-year renewal at market rate. Market rate is to be determined by the parties after reasonable agreement. A similar provision was litigated in 2018 in the third DCA in the Jahangiri case. And the court said, look, that's not an agreement. That's not binding on any party. What is market rate? How are we supposed to determine it? What are the factors? What happens if the parties don't agree? And so the court held that those sort of bare agreements to agree in leases are void and unenforceable. So I have seen landlords who will attempt to put those provisions in. Frankly, it allows them to exert greater control at the end of the original term. But really, if the parties are going to determine the rent rate, then they're left with a couple different options, right? You can gamble on what the rate is going to be in 5, 10, 15 years. Is a 3% increase going to be enough 10 years from now? Is that what the market? Who knows? Nobody knows what the market's doing in 10 years. The preferred provision is a baseball-style arbitration provision, where you have 2 appraisers, one selected by landlord, one selected by tenant. They have to meet certain minimum qualifications as set forth in the provision. And if those 2 appraisers don't agree, then they agree on a third appraiser. And this is where it's key. The third appraiser is tasked with only choosing one of those original appraisals. And the reason that's important instead of a compromise position is it incentivizes everybody on the front end of the appraisal process to come up with a reasonable appraisal instead of one party, jacking the rent rate up and another artificially lowering it. You have to squarely say, look, we need to be reasonable. I have seen more complicated and have litigated more complicated arbitration provisions where you have 2 appraisers and then those appraisals are presented to an arbitration panel, and the panel then determines its own rate, taking into account those appraisals but not being bound by them. And I can tell you that although it got to a final conclusion, at the end of that process, my experience was that landlord and tenant genuinely disliked each other. And so it's about creating a simple process that incentivizes the parties to be fair and is over fast. Because if you get to a point where your lawyers are writing briefs to arbitration panels, it doesn't bode well for a future business relationship. Brings us to the next topic, which until recently has not been a controversial topic at all. And frankly, I don't know that a lot of lawyers are plugged into this yet. And we're talking about attorney's fees, right? They're often addressed in leases. Sometimes they're in favor of landlord fees for the costs of collection But what I want to talk specifically about are prevailing party attorney's fees. Now, there is the quote unquote American rule, which says that a party is not entitled to its attorney's fees for litigation unless it is provided for by statute or contract. If it's not in one of those, then there's no entitlement to fees. In most commercial leases, the overwhelming majority, there is a prevailing party fee provision. Sometimes those provisions are written in a one-sided manner. Well, the state of Florida, the legislature has addressed that issue in Section 57105 Florida statutes and holds that those provisions, even if they're unilateral and only favor one party, are automatically interpreted as reciprocal provisions. So as a result, not a lot of parties spend a lot of time on the attorney fee provision. Whatever you write, it's going to end up being reciprocal, no big deal. Well, last year, in a family law case, Levy versus Levy, the Florida Supreme Court looked at a really interesting attorney fee provision that addressed, quote, legal action against the other by reason of the other's failure to abide by the agreement. The party who is found to be in violation shall pay to the other who prevails. The key being, the party who is found to be in violation shall pay to the other who prevails. So the court held that finding a violation of the underlying agreement, in this case it was a marital settlement agreement, but finding a violation of that underlying agreement was a necessary condition precedent to the recovery of attorney's fees. And in that case, because the defendant had only defended the action and hadn't established that the plaintiff was in violation, the court said the defendant, even though they won, was not entitled to prevailing party fees. So one of the questions that ran across my mind was, well, what happens if we put that in the landlord-tenant context? What if we start dropping that lease provision into leases? Who is more likely to file a lawsuit? It's the landlord, in my experience. A landlord is more likely to allege that a tenant is in default. And let's say the tenant wins with a similar provision like this. They win, they show that the monetary demand letter was insufficient, that the landlord didn't check the right boxes, and they win on a motion to dismiss. Great, tenant's the prevailing party. But are they the prevailing party who showed that the other party was in violation of the agreement? No. So the tenant wouldn't be entitled to attorney's fees under those circumstances. So it raises an interesting question. It's a risk because obviously as a landlord, you could be sued by your tenant. You could win in that defensive litigation and not be entitled to attorney's fees. But I think there's a good business reason for landlords to start trying to put that provision into their leases. Next topic is acceleration of rental. Acceleration of rental is really the nuclear weapon in damages actions. And it provides generally that in the event of a default, you can declare all sums due and owing for the remainder of the term to be immediately due. Now, there's case law that layers complexities on top of it, where you have to discount it to present value. There's an affirmative duty to mitigate, and that's in order to prevent double recovery. So once the property is relet, then you're not entitled to acceleration. But what's key is this remedy of acceleration is not statutory and it's not in common law. So it has to be expressly stated in the lease. And one of the things that we'll see often in national forms of lease, and it comes out of, I believe it comes out of the California statute on acceleration, is you'll see what I call a California acceleration provision, which provides that all sums due for the remainder of the lease term, less the reasonable rental value. As a landlord, I'll tell you, I hate that provision. As a tenant, I love it. Why? Because it invites dispute. And the whole goal when you are prosecuting an action against a tenant when they've breached the lease is really to get it resolved as fast as possible, usually through a mechanism called summary judgment. And summary judgment can only be granted when there is no genuine issue of material fact. Well, what is the reasonable rental value of the premises for the remainder of the term? My expert says it's X. Your expert says it's Y. That sounds like something that needs to go to a trial. So when we look at those acceleration of rental provisions, those are some of the issues that are jumping around. Two more topics before Mr. Rader will take over. First is waiver of notice. So under Florida law, in Chapter 83, there is a 3-day pay or surrender notice that Shawn will talk about more in detail. But there is a way to waive its requirement in the lease. It has to be an express waiver. And one of the great things is that when tenants are defending litigation, often the first things that they will do is try to attack the form of the notice. You sent it via Federal Express instead of certified mail, and it's required to be certified mail under the lease. Those kind of technical defects in the letter. Well, one great way to get rid of those technical defenses is if there's a waiver of the requirement of notice altogether. Now, with that said, if I'm representing a tenant, never waive notice. I mean, it provides you your first line of defense if you're sued. It also and market really requires notice. But if you want to put together a really strong landlord-friendly form, you can put that waiver of notice provision in your lease. Now, last, I'm going to briefly talk about a topic that sometimes comes up in negotiations, and it's the statutory landlord's lien in Chapter 83 Florida statutes. This is a landlord's lien for rent. Now, most lease provisions most lease forms will have a provision for it, and it comes up in negotiations and subordination requests. And my position is that in probably 95, maybe 97, 99% of cases, landlords should not care about the landlord's lien. And here's why. It is a lien on the tenant's personal property, but it's not perfected until you file your lawsuit. And then it's only perfected when something called a writ of distress is issued by the court and posted at the property. So, and then it allows the landlord to sell the tenant's personal property to recoup its rent. With most tenancies, that personal property is not going to be anything that you want to touch or try to sell, right? In a restaurant, you got food that's spoiling, or those of you who have leased out restaurant space before know that kitchen equipment is very expensive to buy, but almost impossible to sell for some reason. It is an extremely expensive process to enforce because it ends up being kind of an injunction light, and it requires the posting of a bond by the landlord. In 18 years of doing this, I've attempted to enforce a writ of distress twice, and both times the tenant has vacated before the sheriff has gotten to the door. And the effect of that is that the writ of distress only applies to the real property that is at the premises or kept in the ordinary course of business. And so once it's off the premises, it's gone. And even in the retail context, your goal when you file a lawsuit is to get paid. And in the retail context, what it does is this writ of distress prevents the tenant literally from selling the merchandise at the premises, which is great from a leverage standpoint, but you're putting the tenant out of business and really eliminating their ability to pay. So when it comes time to negotiating these landlord liens, I don't frankly think they're worth the amount of effort that some people put into them. So those are the tips and tricks and hot topics from our commercial leasing practice group. And now I'll turn it over to Shawn Rader.
Thank you, Jamie. And as Jamie mentioned at the beginning of his presentation, if you have any questions, you can use the question and answer format at the bottom of your screen to pose those, and Jamie will track them for us as I go along. I wanted to take a few minutes to talk about lease provisions for a healthy eviction. And some of these sound so simple, so basic, but since I've been practicing at the firm for 43 years and done a lot of commercial landlord-tenant litigation. I can tell you that it's sometimes the little things that really cause you to stumble in the court of law. The first provision that I would request that both the brokers and the property managers focus on is who are the parties? Because I have seen many leases where in the introductory paragraph, the landlord and tenant are described, for example, as individuals or as LLCs. And then in the body of the definitions, you find that the tenant is suddenly referred to as a corporation or a corp or an Inc. And then you go back to the signature page and you have yet another or a differing entity who is signing as a party. And that can lead to a lot of complications, especially obviously in the area of moving for monetary damages. You have to be able to identify your target. The next thing is the identification of the premises. And that is especially in retail settings. A lot of retail centers will have unit numbers identifying the spaces in the lease or suites. Yet there is one street address for the center. And what happens is when we send the sheriff out to serve the writ of possession at the end, if that unit number or suite number that is in the lease is not in the writ, they'll come back and say, well, we couldn't find it. You say, well, did it say Dolls of America? And the answer is, yeah, but it didn't have the unit number on it. Or the unit number was there, but it wasn't on the writ of possession. So make sure that the premises are properly identified, both in the lease and in your pleadings. The next thing required for an eviction is the notice. Now, Jamie indicated that by law in Florida, and when we're talking only about commercial leases here today, you can waive, you can put a waiver provision in the lease. And the waiver is enforceable, and there is a good reason, as Jamie said, to have it, so that if the tenant launches an attack on your eviction by saying the notice was deficient, you can always say, well, that was just sent as a courtesy. The lease doesn't even require it because you waived it. Nevertheless, I think a waiver is more often than not important simply because the judges in eviction courts are used to seeing them. So that's something to keep in mind. Look at the notice provisions very carefully. In most commercial leases, it says that a notice to a tenant or a notice to a landlord must be in writing and must be delivered by overnight delivery or certified mail return receipt requested. But when you look at Chapter 83, Part 1 on commercial evictions, what the law requires is that the notice be hand delivered to the premises. And so what we do is we do both. And let me strongly recommend against the practice of having the landlord or the landlord's agent or the property manager sign off on the delivery. I delivered this to the premises on such and such a day, because you can anticipate that when you get into court, the response from the tenant is going to be, oh, no, you didn't. I never saw that notice. Spend the $70 or $100, hire a process server. They're considered officers of the court. They will not only deliver it, but they will provide to you an affidavit of service indicating where and when they serve the tenant. And no judge is going to question them. And if the tenant still claims they didn't get it, then you have a third-party professional who can come in and support your claim. Now, the 3-day notice required by Chapter 83 in the absence of any other requirement in the lease. And in a commercial lease, by the way, you can have more extended times for your notice. It could be a 5-day, 10-day, 15-day curative period. statute calls for at least 3 days. The first thing you want to do is you have to set forth the amount of rent that is in default. This requires a careful examination of your lease to determine exactly what numbers are referred to in the lease with the magic words rent or additional rent. Common area maintenance, insurance costs, merchant association dues. As long as they are defined as rent or additional rent, you may include those amounts in the 3-day notice. What I like to see in a lease is what I call the dragnet provision, which is fairly common. And that simply states that all amounts due from the tenant under the terms of this lease are to be considered rent. Then you don't have to worry about it. You can throw everything in there. Late fees, interest, etc. There's no self-help in Florida. I have clients who have properties here in Florida and in Texas, and they do not understand when I tell them you must go through the court system to get your property back. Because in Texas, if a tenant defaults on the rent, you just take your padlock out, go down to the premises and lock them out. Don't do that here. Even if the lease form you're using says that upon default, the landlord has the right to go in and retake possession. You're going to get yourself in trouble if you do that. Another and final provision I would point
Shawn,
out. Yes.
I'm going to jump in because we have a question on what can constitute additional rent. And so one of our viewers would like to know if sales tax can be considered additional rent. And I'll answer that. The answer is yes. If you have a provision that says all sums due hereunder shall be considered rent or additional rent, that also includes sales tax. So we wouldn't have to send a separate letter for sales tax amounts. Now, with that said, it does not create sort of that infinite loop where you are having to charge sales tax on your sales tax. That's one of the questions that I've asked our tax attorneys before. But it would, for purposes of lease enforcement, be considered rent if it was under that dragnet or catch-all provision. Return to your regular programming.
Thank you, Jamie. And I agree with that. Agree with that assessment. So when you have that dragnet in there, and I say anything could be considered rent, I meant everything and anything. Now let's look at the eviction process itself. The first thing that we're going to do, your tenant has failed to pay rent. What do? Well, we know you've got to send the 3-day notice. So you put that together. But the first thing you have to ask yourself is, when was the default? The majority of leases simply say that rent is due on or before the 1st of each month. And then when you turn to the default provision, it says a default is created if the rent is not paid timely. And that's fine, that's easy. That means the rent's due on the 1st, and at 12:01 a.m. on the 2nd, you don't have the rent, you can send your 3-day notice. However, many leases do have grace periods. And what the default provision will say, if the rent is not, the rent's due on the 1st, but if it's not paid by the 5th, then it's a default. And in that case, you have to factor those extra days in. It will be day 6 before you can send your 3-day notice. So just be careful to look at that and make sure whether you're dealing with a straight out default provision or a grace period. When you're preparing your 3-day notice, presumably you'll have me or Jamie doing it for you. But if not, Chapter 83.20 of the Florida statutes has the form that the Florida Supreme Court has approved that you can use. And the courts in enforcing them will require that the rent be identified and that the magic words that the tenant shall either pay the amount due or surrender possession of the premises. That option for the tenant has to be in there. If it's not, it is a deficient notice. We've already looked at what rent is, so you know the number that you can plug in there. Assuming that the tenant does not cure in the curative period, which we're using as an example 3 days, that 3 days is a window of opportunity. The landlord must accept payment if full payment is offered during those 3 days. If it's not, then the tenant's in default and you're ready to move forward. You have your eviction suit prepared, you file it, you are ready to have it served. An eviction suit is called an in rem action because the action itself is not for money. It is not against an individual. You want your premises back. So it's called in rem. And the reason that's important is because if you're filing a suit for monetary damages, you must serve the tenant individually. The premises, however, are available for service in an eviction action. If the process server goes out to the premises twice in 6 hours, 6 hours apart, and no one's there, or the tenant's not there, but an employee is, the process server has the right to post, tape, or nail the summons and complaint on the premises. And this is undertaken pursuant to Chapter 55, which is the summary procedure. So it's a quick turnaround. The tenant only has 5 business days in which to file a response to the complaint. Now, Florida is what we call a pay-to-play state. If a tenant wants to contest the eviction suit on any basis, they must place into the registry of court the amount of rent claimed as due in the complaint. Now, this is a very powerful weapon. And the only way the tenant can get around it is they have the right to contest the amount. They can ask the court for an immediate hearing to say that that is too much. And the court will hold an evidentiary hearing, determine what rent must be paid, and it's got to be put into the registry of court within 24 hours. Needless to say, I don't think most tenants plan on not paying their rent. If they haven't paid their rent, there's probably a good business reason why they haven't. And once they're served with that order that says either you put the rent that's owed, the $40,000, into the registry of court tomorrow, or I'm granting the final judgment of eviction to the landlord. It might not be fair. Remember back in the 80s, when we didn't have that statute in effect, what tenants would do is when eviction suits were filed, they would delay, and landlords and owners eventually went to the legislature and said, this is not fair. Property's tied up, we're not getting any money, and the likelihood is at the end of the day, the tenant's going to be bankrupt or insolvent. So this was the legislature's answer, and it is kind of a sledgehammer. But if you're representing the tenant in the eviction, it's a tough one to get over. Frankly, that is about all I need to tell you about the eviction suits. If the tenant does file an answer and contest the eviction and put some money in the registry of court, then you will be sent to mediation by the judge to see if a settlement can be reached. And if not, then you will have a trial. Customarily, in an eviction case, you'll need to have the property manager and bookkeeper as witnesses to identify the lease, to talk about the terms, any questions the judges have, and to offer evidence of the amounts that are due. If the judge rules in favor of the landlord, then a final judgment of eviction is entered. The clerk of court issues what's called a writ of possession. That is given to the sheriff. The sheriff deputies come out. They post it on the door and come back 24 hours later to remove any tenants that remain there and turn over possession to the landlord. The landlord on that day will want to have a locksmith there to change the locks. If the judge rules in favor of the tenant, for whatever reason, the landlord is entitled to the rent that's been held in the registry of court, and the parties go back to their boxing corners. So that is the quick summary of the eviction proceedings.
Yeah, Shawn, and one of the nice things about at least monetary defaults in county court is that they are supposed to happen on an expedited basis. Until recently, Shawn and I would look you in the eye and say that on a monetary default, a county court judge will get you to trial in 6 to 7 weeks. Recently, that has not been the case because the courts have been very backlogged, and so it's now taking longer to get to trial. But between the rent determination hearing and some other remedies we have, it's usually a relatively fast process. Never fast enough for landlords. But Shawn, one of the questions that's popped up in the question and answer panel is about the witness requirements under Florida law, and we know that witnesses are no longer required on any lease, regardless of term. That the legislature modified that statute. But one question that popped up was whether or not that statutory revision was retroactive. So if you had an old lease that should have required 2 witnesses but did not, and the answer I've got to that is I don't believe the statute was retroactive. However, there is a very good and well-developed body of case law that deals with the witness requirement and estoppel in the lease context. And so what the cases say is that if you have a tenant whose signature was not witnessed, but that tenant has been paying rent and has been enjoying the beneficial occupancy of the property, the tenant is estopped. So they are barred at law from denying that the lease is enforceable because they've accepted the benefits of the transaction. And so in answer to the question that popped up, regardless of whether the statute is retroactive, I don't believe it is. Even for those old leases, if the parties have been acting as though the lease is in force, the estoppel case law is very, very strong on enforcing those leases, regardless of the witness requirement.
And that's true vis-a-vis the landlords as well. Sometimes landlords, for whatever reason, want to get rid of the tenant, and they discover that, there was no witnesses or there was only one. But if the landlord has had the benefit of the lease payments all those years or months, the court is not going to support throwing out or terminating the lease at that point based on the absence of a signature. Are there any other questions?
If there are no more questions that pop up in the question and answer, I just want to sincerely, and I recognize a number of the names of the attendees, and sincerely thank everybody for taking time out of their day. Hopefully you came away with 1 or 2 takeaways that you can put into your practice, and which will result in you having to call me or Shawn less frequently, because you're going to send out perfect demand letters now and run through that process.
Yes, thank you very much. We appreciate it.
And before we go, it looks like I see one question popped up down here at the bottom, if I can get to it. It was just a thank you. Well, you're very welcome, and everybody have a great day. We're going to close out now.
Bye-bye.